You are about to see the terms and conditions for the webinar that is about to follow. Please take the time to read them before we start. Hello and welcome to today's 9 St John Street Chambers Employment Insights webinar. I am Jenny Ferrario.
And I am Laura Kay.
And we are employment law barristers. During the COVID-19 pandemic, the employment team have been presenting weekly question and answer webinars on various aspects of the furlough scheme. Today, Laura and I will be sharing our top 5 tips for a fair redundancy process.
Now, before we come to the tips, it's worth covering a couple of points on redundancy and furlough. Government figures estimate that 4 million people in the UK have been furloughed. Just this week, British Airways have also announced approximately 12,000 redundancies. And as many other businesses start to assess the impact of COVID-19, we anticipate that unfortunately many more will follow. There does not appear to be anything in the UK government guidance to suggest you cannot be placed at risk of redundancy whilst the furlough scheme is operational. This is different to the approach being taken in some European countries where there has been a ban imposed on redundancies during the pandemic. The challenges provided by COVID-19 will not allow employers to overlook the principles of fairness, and therefore, to avoid a potential claim, employers must follow the required processes, no matter how large or small the business is. This includes consultation. COVID-19 is unlikely to be considered a special circumstance within the meaning of Section 188, subsection 7 of the Trade Union and Labour Relations Consolidation Act 1992. We would also expect employers to give careful consideration as to why furlough is not a reasonable alternative to making redundancies. And employers need to be prepared for considerable tribunal scrutiny on this issue, should they choose to consult whilst the furlough scheme is live. We would always recommend that you take independent legal advice before commencing with a consultation process, particularly during the coronavirus pandemic.
So what are our 5 top tips? Our first tip relates to the early stages of a redundancy. As an employer, if you are considering making a role redundant, before you begin the process, you should check to see if the organisation is recruiting for a similar position, whether that's in the same geographical area or anywhere in the country. I was recently before an employment tribunal where the judge found that the employer ought to have at least considered offering the vacant role to the employee that was at risk of redundancy, particularly because there was no question as to this person's competency. And even where a candidate for the vacant position had been identified and offered the role, the judge found that consideration should have been given to slotting the at-risk employee into that new role. The tribunal actually went a stage further and said that had the vacant role been filled and the new employee had started work, that the employer should have considered creating a pool for redundancy, which included the at-risk employee and the new one. And a failure to give any consideration to that rendered the redundancy dismissal as unfair.
Our second tip is to start your consultation when there is a proposal to dismiss. Employers can often fall into the trap of counting back the prescribed minimum number of consultation days in the case of collective redundancies from the date the first dismissal could take effect. And this can contribute to employees feeling as if the business is simply going through the motions. In truth, consultation should take place as soon as a proposal of redundancy is on the table. If your business plans or budget forecasts suggest redundancies were proposed, you can leave yourself open to criticism for not consulting at that stage. It is, of course, a judgment call, but if redundancies are proposed, or you have made proposals which could result in redundancies, start your consultations. And don't forget your obligations in certain circumstances to consult with the unions.
All of us at the moment should try and be at least realistic about our immediate future. And with this in mind, my third tip for both employers and employees is that during the early stages of redundancy, consideration should be given by both parties to the at-risk employee taking on a suitable alternative, lesser role. Our uncertain futures mean that we should be alert to all possibilities, hopefully, as I say, for the short term only. Since January 2018, case law has placed a duty upon an employer to consider the at-risk employee for a less senior role where it is a suitable one. And of course, all of the normal fair criteria apply, even if it involves an at-risk employee being paid less. This doesn't take away from the fact that employees at risk should be scrupulous in checking for suitable alternative employment in the organisation, but it clearly extends the historical obligation of it just being for the employee to look for a lesser role. It now requires the employer to do it as well. You might be familiar with the term, it's known as bumping, and we suspect that it will become far more prevalent in these very challenging times.
Many claims that we see relating to redundancy processes, whether they are for unfair dismissal or discrimination, arise from issues relating to selection criteria. So for tip 4, please try and follow these steps. Firstly, reasonably apply your mind to the question of a selection criteria. Set aside time in your redundancy planning meetings to this issue and make a note of your discussions. Evidence on this issue is often lacking in cases. Secondly, objectively assess your criteria and ensure that each one is appropriate, fair, and non-discriminatory. Run through various scenarios and see how it would work in practice. Consider whether any adjustments are necessary, including the removal of a certain criteria, particularly having regard to your duties under the Equality Act. Again, make notes to evidence your discussions. Thirdly, we ideally want employers to provide employees with their selection criteria and hear representations on it. Be prepared to evidence good reasons why you chose not to adopt their suggestions. And finally, ensure that the inclusion of each criteria is justifiable. By way of example, an attendance criteria could give rise to discrimination arguments, so it is imperative to give real thought as to why it is necessary, having regard to the principles of proportionality and your duties under the Equality Act. And finally, tip 5, a cautionary tale. Whilst the thrust of the legislation is to reasonably avoid redundancies, claims can actually arise where employees suggest they should have been made redundant and not retained in an alternative role, possibly at a lesser salary. Make contractual variations by consent, and please don't be caught out.
Today, Laura and I have provided a mere snapshot of potential issues that could be faced when it comes to redundancy. More videos from our Insights team will follow, but in the meantime, as an employer or employee, if you think that you might benefit from some advice from our employment team, please get in touch with Chambers either on the telephone or by emailing us at the address provided with this post. For now, from both Laura and I, we thank you very much for watching, and we hope that you and your families stay safe and well during these very difficult times.